Um, I'm still not entirely comfortable with that. We're probably giving all the competing values. That's probably the best solution.
Well, hi, it's so great to see you.
Great to see you too.
And this is my one of my research assistants, Sarah Osborne.
Hi, Sarah.
Hi.
I have been wanting to talk to you for the longest time because you wrote about secret settlement agreements in harassment and discrimination cases before anyone else. You wrote that great law review article in 2006. So the first thing I wanted to ask you was, how did you decide to work on this question?
Well, this is a question that has bothered me forever because now I both teach doctrinal courses and I run an employment law clinic. So I actually litigate with students employment discrimination cases. And even before I started teaching, I did that. And it always bothered me tremendously that this was like a non negotiable clause. And no matter how much I argued about it and how much my clients didn't like it, you just couldn't settle a case without it. And my approach was not even so much as protecting the harassers, which, I was really concerned that the courts never saw what happened to these cases. They never saw that they actually settled and they settled favorably because the settlements were secret. So, the judges didn't know. They just assumed they sort of went away and probably went away for nuisance value, as well as it was almost impossible to advise clients about, settlement ranges because there was just no information available.
Can you tell us a little bit more about what is the matter with secret settlement agreements?
They give the impression that there is no more sexual harassment. You asked people 2 years ago, oh, how much sexual harassment is there really going on in the workplace? They would say, oh, no, that's an old problem. That's been taken care of.
Minna, could you tell us about how lawyers were able to make these agreements secret?
That's an interesting question. The uh, the word from the employer bar the management bar was that if a settlement was publicized, that every disgruntled employee would line up to get rich quick on the company, and they just stood firm on this provision, and the plaintiffs bar didn't really fight back. And I think the reason why the plaintiffs bar didn't fight back was because they work primarily today on a contingency fee basis. And so the more they can maximize the plaintiff settlement, and confidentiality does maximize or at least contribute to a plaintiff settlement, they weren't going to fight it.
How would you characterize the way judges thought about this problem before the Me Too movement?
Employment discrimination makes up something like 25% of the federal court docket. And many judges, I think, resent the amount of time and the bulk of these cases on their docket. And these are messy cases, facts that they don't really want to get into. It's only one step up from family matters, right? And that's why I think we saw this incredible um, burgeoning of summary judgment in employment discrimination cases. Now, that's been moved back a little bit, I think. I think the Me Too movement and some other criticism of summary judgment in these cases has led to at least the circuits pulling back, saying, don't grant summary judgment quite so quickly. You have to really look for factual disputes.
So what else do you think has changed since post Me Too?
For one thing, it's now become a less of a stigma to have alleged sexual harassment. I think women are obviously more willing to talk about it, and I think having raised this issue with your prior employer doesn't stigmatize you forever and keeping you from getting another job. So I think there's more acceptance of talking about these things publicly.
What would be a better way to handle this problem moving forward then?
I think 8 states now have passed statutes that deal with confidentiality and various kinds of discrimination. And basically, they're a mess. One problem with these statutes is that many of them just deal with sexual harassment, and that's a problem to begin with. Because as we know, they're all forms of not only harassment, but just plain discrimination in the workplace. Racial harassment cases are just as horrible and just as destructive, and there are plenty of them, and why they should be treated any differently than sexual harassment, I can't understand. But really, the question is, when should the parties be able to contract for confidentiality? Uh, the place where I definitely think they should not be allowed is once a matter is filed in court. Once a matter is filed in court, it is public. The complaint is public. The plaintiff's name is there. If those facts are already out there, what is the purpose of protecting a settlement agreement? We don't protect settlement agreements in other contexts, in tort contexts, in malpractice contexts. Those are publicly available. Pre-litigation is sort of raises different issues. Um, I think that there are arguments in favor of confidentiality pre-litigation. If we allow confidentiality pre-litigation, I think that will make employers more willing to settle prior to litigation, because that if they want confidentiality, they have to do it before a case is filed. So that puts some pressure on the early settlement, when you don't need to invest a great deal in litigation, and that's a good thing. I'm still not entirely comfortable with that. We're probably giving all the competing values. That's probably the best solution.